This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why it's expensive to lie to your insurer, and why fraud in the inception of a policy allows the insurer to rescind and get back any money it advanced before it learned that it had been lied to. A man by the name of Lamin Fatty appealed the trial court's order granting summary disposition to Farm Bureau Insurance Company of Michigan on the basis of finding Fatty's fraud was grounds for contract rescission and reimbursement of payments made. In Lamin Fatty v. Farm Bureau, the Court of Appeals of Michigan on November 21, 2023, resolved the dispute. After a motor vehicle accident where Fatty sustained bodily injuries, the issue of rescission was raised when it was discovered that at the time of the accident, Fatty was insured by Farm Bureau under the No Fault Act of Michigan. Fatty obtained insurance with Farm Bureau on July 17, 2019. On the application for insurance, Fatty answered the following question in the negative. Quote, "Are any vehicles to be insured used to carry persons for a fee?" Close quote. Fatty, after the accident, received treatment for his injuries at Columbia Clinic, among other medical facilities, and indicated to providers that he was rear-ended as an Uber driver. Uber records indicated that Fatty began working as an Uber driver in May of 2019 before he applied for the insurance and drove for Uber on the day of the accident. Fatty's drive log shows he picked up a rider at 6:05 p.m. and dropped them off at 6:30. Fatty picked up another rider at 6:38 and dropped them off at their destination at 6:50 p.m. Fatty continued picking up riders and completing trips that night until 8:17 p.m. After this discovery, Farm Bureau filed a counterclaim on the basis of fraud, requesting reimbursement of benefits paid to or on behalf of Fatty with regard to the accident. The trial court granted Farm Bureau's motion for summary disposition of the counterclaim, including its request for reimbursement of $104,730.82 for benefits paid because the policy was rescinded under the doctrine of fraud in the procurement. The trial court also found Fatty's fraud entitled Farm Bureau to attorney's fees under the No Fault Act and costs. Specifically, the trial court found the requested cost of $2,599.50 were reasonable and awarded $10,000 in attorney's fees. Fatty, of course, appealed. The trial court properly rescinded the insurance policy according to the Court of Appeals because Fatty committed fraud in the procurement of the contract by explicitly denying using his vehicle to carry passengers for a fee. Because of this rescission, summary disposition of Fatty's claims was appropriate without regard to whether Fatty was driving for Uber at the time of the accident. Fraud in the inducement to enter a contract renders the contract voidable at the option of an insurer who issued the policy, and an insurer has a reasonable right to expect honesty in the application for insurance, because the covenant of good faith and fair dealing applies both to the insurer and the insured. Rescission abrogates the contract and restores the parties to their respective positions had the contract never been made. A court must not hold an insurance company liable for a risk that it did not assume. Farm Bureau's evidence in the form of the litigation representative's affidavit that he told the truth the policy would not have been issued. It would have been refused, and that testimony was unrefuted and established the materiality of the misrepresentation. Fatty's denial of carrying passengers for a fee was determined to be a material representation, and as such was grounds to rescind the policy as requested by Farm Bureau, because it had been deceived, and had it been told the truth, it never would have issued the policy. Reimbursement of the PIP benefits paid to Fatty was an appropriate remedy following rescission because the claim was fraudulent and Farm Bureau was the prevailing party. The award of attorney's fees and costs was also proper. The trial court properly awarded attorney's fees to Farm Bureau. Farm Bureau was forced to defend against a claim pursued under a policy that was procured by fraud. Therefore, the award is within the range of reasonable and principled outcomes and was not an abuse of discretion. Accordingly, the award of attorney's fees and costs to Farm Bureau was found by the Court of Appeal to be proper. The trial court properly rescinded the contract because Fatty committed fraud in the procurement by explicitly denying he used his vehicle to carry passengers for a fee when he was actively working as an Uber driver. Because the claim was fraudulent and Farm Bureau was the prevailing party, the award of attorney's fees and costs was also proper. In my opinion, rescission is an equitable remedy that allows a contract to be voided from its inception as a result of fraud in the inception. Farm Bureau was deceived by Fatty, who lied about a material fact that he was carrying passengers as an Uber driver. He received no-fault benefits as a result of this fraud, and the court properly ordered the policy rescinded and ordered Fatty to repay the benefits he received, plus attorney's fees it took Farm Bureau to defeat its claim. Fatty learned that fraud does not pay, and that he should never lie to a prospective insurer, and hopefully others will learn from his error. This video is adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. Please tell your friends and colleagues about the blog and the videos and let them subscribe to the blog. And if you subscribe, you will receive notice of every blog posting, usually 5 or 6 a week. And you will also receive access to the more than 4,700 blog postings. If you're interested in more detail about insurance, insurance claims, insurance fraud, and insurance law, please consider for a very small fee subscribing to my Substack publications or my locals community. Thank you for your attention.